thank you all for coming along. We are just waiting for one or two more stragglers. I think we're waiting for one or two more people to actually come in. My name is Elliot Pressman of Barnet Wills. I'll be joined tonight by Andrew Brettle from the Money Mock Co. And I think most of the people that we're expecting are actually here. So I'm going to make a start. So let's just dive straight in. So before we actually start the webinar proper, let me just do a little bit of housekeeping. Some of you obviously are familiar with Zoom or Zoom meetings, but Zoom webinar is slightly different. So you'll see that the chat box that you have is actually going to be disabled. So if anybody has any questions, if you look at the bottom of your screen there, you'll see the question and answer button, and you can type your questions into there. And there will be some natural pauses during the presentations, and we'll try and answer questions as we go along and in between some of the segments. But Andrew and I will hang on towards the end of the seminar or webinar, and we'll answer any questions that you have at the end. Okay, just to repeat myself. So let's just drive straight into the agenda. So I'm going to kick off and we'll talk about wills and trusts. Andrew's then going to talk about streaming your finances, increasing your disposable income, and how you can better budget. And then I will finish off by talking about lasting powers of attorney. So let's just dive straight in. Now, I'm going to assume for the purposes of this evening that everybody that's logged on thinks that having a will is a good thing, and that nobody here thinks that it's okay not to have one. If you think not having a will is right, then perhaps speak to me later and we'll talk about intestacy and what that involves. So let's have a look at a typical will. Now, I've got my virtual couple here, Bill and Vera, but the same rules will apply whether it's a same-sex marriage or a civil partnership. And then we've got their 4 children who, for some strange reason, all dress in the same color. So Bill and Vera, they pop along to their local high street solicitor, or perhaps they've invited a will writer into their home, and they say, "We'd like to make wills, please." And normally the first thing that gets asked is, "Sure, no problem at all. You've come to the right place. What would you like to do?" Now, as an estate planner, that usually irks me, I have to say, because not a lot of advice has been given now. The question has been thrown right back to the client to say, "You're the experts. You're supposed to know what you want. Tell me what you want, and I'll draft it up." But Bill and Vera are not the experts, so they will say what 99% of people in that situation will say. So Bill will say, "Well, look, if I die first, everything should go to my wife, Vera. And when Vera dies, it should then go equally to all the 4 children, right?" And usually there's a mirror will where if Vera dies first, it will go to Bill. And then when Bill dies, again, it will go equally between the 4 children. And that is a standard will. And 95+% of wills that I review are along those lines. And if those of you that are on tonight have a will, I would expect it to be along that format. So what could possibly go wrong? Well, let's have a look at a case study. So here we have Arthur and Jenny, who have been married for approximately 40 years. They've got 2 grown-up sons, Mark and Andrew. Mark and Andrew are actually my clients first, which is how I got to meet them. And Mark is also married to Alison. They own their own home. Their total estate is worth somewhere in the order of about £750,000. And in fact, Mark and Alison do have a couple of children as well. So there are grandchildren there as well. Now, when Jenny was in her mid to late 40s, she was diagnosed with dementia. And by the time that she had reached her early to mid 50s, it had gotten so bad that Arthur decided that the best thing to do would be to retire early so he could look after her full time. And that's what he did. Unfortunately, about a year later, he had a heart attack and died. So under the terms of his will, everything passed over to Jenny. Obviously, the wills were made before she lost capacity. Now, Mark and Andrew obviously were not in the position that their dad was. They couldn't give mum the same level of care that daddy did. They had, work, families, and so on. And so they decided that the best course of action would be for Jenny to actually go into a residential care home where she could get specialist care for her dementia. And this is really where the problem started. Because there wasn't a lot of cash in the estate, most of that was actually in the family home, the local authority got involved and they actually forced the sale of the family home to cover the cost of Jenny's care fees. And this is very common. Somewhere in the region of 60 to 70,000 people every year are having their homes forcibly sold by the local authorities to cover the cost of care fees. So by the time Jenny passed away about 4 or 5 years later, the local authority had spent over half the money, and only 360,000 of the 750 actually remained. So obviously that was split equally between the two boys, and Mark and Andrew inherited £180,000 each. Now, within about 7 months or so, Mark waved bye-bye to £90,000 because Alison actually divorced him, and she took half of everything, including half of his inheritance. Andrew, on the other hand, wasn't so lucky. Andrew was actually in financial difficulties. His business was failing, and he was in debt to the tune of nearly £250,000. So as soon as his creditors found out that he'd come into some money, they were all over him. And he ended up with absolutely nothing. His creditors actually took the lot. So despite having perfectly valid wills, only 90,000 from the original 750 of Arthur and Jenny's estate actually ended up where it's supposed to, right? That is just 12% of their estate. The other 88%, some £660,000, ended up in the wrong hands, contrary to Arthur and Jenny's wishes. And, they're probably still rolling around in their graves, cursing the solicitor that drafted those wills. Not just because they'd lost them 660 grand, but they weren't even made aware of the risks or the potential of these losses. Had they been made aware, they would have had an opportunity to put some planning or do something in place, and they'd have had a fighting chance in not losing some of that money. So this particular case illustrates 3 of the 5 main threats that your will just will not help you with. Okay, we've obviously got care fees, as in with Jenny. We've got divorce of a beneficiary, and we've got creditors and bankruptcy. And they're all very common. You'd be surprised. There are very common ways that people actually lose their inheritance. But they're actually not the most common. There is actually one threat that is actually far more common than than these 3. And I'm actually not talking about tax. So if you look at the bottom middle of your screen there, excuse me, just take a drink of water. If you look at the bottom middle there, the chap sitting on Southend Beach there is a client of mine. His name is Stuart Hurd. And Stuart is on a one-man mission to make mirror wills illegal. Obviously, that's not going to happen, but his depth of feeling runs very deep. But the story really starts with his father, William. So after Stuart's mother died, Stuart's father, William, ends up meeting a new lady called Dorothy, and after 18 months or so, they decide to get married and relocate to Wigan. Now, William was aware that when you marry, any wills that you have previously are automatically revoked. And so William and Dorothy popped along to a large firm of solicitors in Wigan, high street firm. We're talking, 7 or 8 fee earners, 25, 30 support staff. So not a small firm, quite a medium-sized firm, I would say. And they popped in, we've just got married. We'd like to make new wills, please. And the solicitor said, yeah, no problem at all. You've come to the right place. What would you like to do? And so William says, well, if I die first, everything should go to Dorothy. And when Dorothy dies, everything should then be split equally between my son Stuart and her son Michael. Or if Dorothy dies first, then it should all come to me. And then when I die, again, it should be split equally between my son Stuart and Dorothy's son Michael. And that's what the solicitor drafted up. And that was the will that was delivered and executed. A few years go by, William passes away. Under the terms of his will, everything passes to Dorothy. And then I think it was about 5 years after William dies, Dorothy then passed away. And that's when Stuart discovered to his horror that, his dad's body was still warm in the ground. The first thing that Dorothy did was pop back to the solicitor and change her will and said, right, I'm changing my will. I now want to leave everything to my son Michael and disinherit Stuart. And so Stuart found himself completely disinherited from his family's inheritance. And one of the reasons that he's so emotional about this, or his blood boils, is a lot of that money that he was expecting had actually been passed down to his father from his grandparents, and some of that from his great-grandparents. So with just a stroke of a pen, Dorothy had actually diverted generations of hard work and savings to a completely different family line, to really a stranger, because Stuart only ever met Michael 2 times, once at his father's funeral and once at Dorothy's. And also, to make matters worse, he promised his daughter that he would help her get on the property ladder, by helping her with a deposit based on this inheritance. But of course, because he was disinherited, he was forced to break his promise to his daughter. So let's just have a quick recap on the threats to your wealth, where your will is actually not going to be effective. So on first death, long-term care fees. If you were to die and your surviving partner went into care, the local authority will go after the assets and they'll go after the properties. Marriage after death, this is not someone remarrying from in the beyond. This is where you die and your surviving partner then marries. If they then either go through a divorce or die before the new partner, that new partner then has your money and can disinherit your children. And, as I mentioned earlier, being disinherited by a step parent is probably the most common way people actually lose out on their inheritances. And then again, creditors and bankruptcy. So if your surviving partner has any sort of issues with creditors or bankruptcy, they could lose the lot. And that's obviously something that Andrew is going to talk about quite a lot to make sure that they are financially stable. When the money then on second death passes to the children, there are still risks. Okay, so you leave money to your kids. If your child goes through a divorce, that's half of your money walking out the door with your ex-daughter-in-law, as in Andrew's case. Sorry, Mark's case with Alison. If your children go through any sort of issues with creditors or bankruptcy, or they themselves have long-term care fees, the local authorities can come after the money that you've left them. And then the last one, I've put generational inheritance tax. An inheritance tax is a generational tax. Okay, you die, there's inheritance tax on your estate, your children then inherit the money, but that inheritance inflates their estate, it adds to their estate. So one day when the same money is passed from them to your grandchildren, it's going to get passed, it's going to get taxed again. Usually we hope that our children, when they've grown up, they usually have their own properties, their own savings. So the allowances are usually taken up, with their own money. So any inherited wealth is usually taxed at the full rate. So how do we stop any of this? What can we do? Is there a way in which we can actually stop all this money ending up in the wrong hands? Well, the solution is to utilize something called a trust. We're probably all familiar with the word, but what is a trust? Well, a trust is actually nothing more than a legal obligation. It's taking a piece of law and using it to wrap around or ring fence your assets so that only the people that you specify can benefit from it. So the trustees are legally responsible for managing the trust assets on behalf of the beneficiaries. What can you put into a trust? Well, pretty much anything of value. You can put your house, you can put cash, investments, insurance policies, the family farm, pretty much anything of value can be settled into a trust. And trusts are nothing new. They've been around since the 11th century, really, when the knights would go off on their crusades. They would turn around to a trusted friend and say, here are the keys to my castle, my lands, my moat, whatever. If I don't make it back from the war, please make sure my family are looked after. And that's really how they were born. And you can create trusts either while you're alive or when you're dead. So creating a trust while you're alive, so that could be you want to settle some money or some cash in or property in or something today, right now. Or if you die, you would actually create a trust, and the trust would be part of the will. It would be drafted into the will. They are exactly the same. They are just drafted into the will document, and they actually don't come to life until after someone dies. So let's just have a look at some quick trust basics. First thing is the settlor. The settlor is the person who creates the trust. So if you're putting some money in now, or if the trust is in your will, you are the settlor. Then you've got the trust property. That's whatever goes in. So that's whether that's your property, your cash, your investments. If you're doing a live trust, you would have an opening balance of £10. It's called a de minimis payment. Think of it as if you open up a bank account, you need a £1 deposit just to create that account. So you create a trust with £10, and then you can add more to it as you go along. Then you have the trustees. These are the people that actually manage and look after the trust and after the trust assets. These are people that you choose, and they can be beneficiaries. In the same way that an executor can be a beneficiary, so can a trustee. And then lastly, you have the beneficiaries. These are the people that you want to benefit, and they can be either named individuals or classes. So classes are my children, grandchildren, nieces and nephews, etc. For a trust to be inheritance tax efficient, then it would have to exclude you as a settlor. And obviously that's not an issue if it's in the will because you died. But if you're creating a live trust, normally it's for the benefit of others, typically the children. So you would be excluded for it to be outside of your estate for inheritance tax purposes. And so when we talk about what a trust is, it is actually nothing more than the legal relationship between those people, the trustee, the settlor, and the beneficiaries. Okay, the actual trust document, the deed of trust, is nothing more than a document that actually formalizes that relationship between those three people. It outlines who the settlor is, who the trustees are, and who the beneficiaries are, and the rest of it is all that their legal powers, on what they can do. Well, they've got full discretion. They can invest the money. They can buy Bitcoin, and so on. So the trustees have complete discretion. But if you're not here, how do the trustees know what you wanted or how you wanted your trust to run? Well, we have an additional document alongside the trust called the Memorandum of Wishes. This is your guidance to your trustees, where you say to them, this is how I want you to run the trust. Okay, give my children the income, but not the capital. Give them some when they're 21, some when they're 25, and so on. So this is your instructions, so the trustees know how that trust should be operated. So we've talked about the wills and some trusts. So let's actually have a look at an example. So here we have Bill. He's died, and through his will, £320,000 has gone into Bill's trust. The trust is for his wife Vera and their 4 children, right? He's made Vera his trustee, and the other trustee can be family member. It could be 1, 2, 3, or all 4 of the children, or it could be a professional. There are sometimes cases where people want to have a professional trustee. Perhaps there is a child that's a vulnerable person who isn't capable of managing their own finances, or so on. So I work with charities, for example, where they have vulnerable children or children with learning difficulties, and in those situations, it's usually an idea to have a professional trustee to manage that. So after Bill dies, Vera gets remarried. So how much of Bill's £320,000 is now taxable by Vera's new husband? Well, actually, none of it. So if Vera gets divorced, or if she dies before the new husband, he's not going to get any of Bill's money. That'll go straight to the children. His son John gets divorced. So how much of Bill's trust fund, or how much of John's share of the trust fund is actually at risk from his divorce? How much is his ex-wife going to get? Again, the answer there is 0. Sharon goes into the office every day, but actually when she gets there, she doesn't do any work, so she goes bankrupt. Her creditors come along. How much of Bill's trust fund can she come after? Well, again, 0. And Alex, well, he has health issues and ends up going into care. So how much of the trust fund is at risk for Alex's care fees by the local authority? Again, 0. And poor old Kate, she passes away. So how much of the trust fund is actually part of her estate for the purposes of calculating her inheritance tax bill to Bill's grandchildren? Again, the answer there is 0. So that really is my segment here on trusts. Are there any sort of questions? I've just got a couple of questions here. So do trusts have an annual fee or retainers? No, they don't. The trustees think it's not like an entity or a limited company or anything like that. It is just simply a piece of law that we're using to ring fence. So if you employ a professional trustee, of course they can charge for their services, but creating the trust and having the trust itself, there are no ongoing fees. Someone's put, can I gift my house to my children? Yes, you can. I wouldn't recommend it. If you gift your house to your children, HMRC have a rule called gift with reservation of benefit. This means that even if you put your children on title, because you're still living in the house, HMRC will still say to you, it's still your home, and therefore, even though your children are on title, we're still going to tax you on it if you die. And you're probably going to give your children a capital gains tax liability. Can you explain briefly how it would be different if the settlor was still alive rather than creating a trust through a will? Well, if you create a trust while you're alive, there could be a number of reasons. So let's take an example. Maybe you're single, divorced or widowed, care fees. You would want to put your house into trust so that local authorities can't come after it. Or it might be the bank of mum and dad want to gift some of money to their children, but they want some element of control. Maybe it's a deposit to buy a house, and they don't want their, son-in-law or daughter-in-law to get their money. So they'll simply create a trust. While they're alive, they are the settlor, so they have powers over and above the other trustees. So they can hire and fire trustees and hire and fire beneficiaries as well, and they still have complete control of the trust. Does the 7-year rule apply for IHT? Yes, it does. So whether you settle money into a trust while you're alive, it is the same 7 years as if you are gifting it absolutely to your children. So for that money to fall outside of your estate, you still have to survive 7 years. 0 tax on beneficiary's death or on my death. Well, if you're making a gift into trust or into an absolute gift, there is no tax. If you survive 7 years, it is outside of your estate, and therefore it will not be subject to inheritance tax when you die. If you die within 7 years of making that gift or making that settlement into a trust, there is a taper and like a pro rata, so it's likely to be a reduced tax bill, but dependent on when you die. There are 1 or 2 more questions coming in, but what I'll do is I'll hang around and I'll take them at the end of the seminar, but I want to hand over now to Andrew. So I'm just going to stop sharing my screen and introduce Andrew of the Money Motco, and thank you very much for now.
Thank you very much, Ellie, and good evening, everybody. Just by way of background, it's probably worthwhile just telling you a little bit about the Money Motco. I founded the company almost 9 years ago to the day, and have been building it up ever since. Where I feel that I can complement what Ellie does is that before you actually go to approach him, a lot of the work that I do would be aimed at trying to get your affairs into some sort of order, in order that he would then be able to, it would make life a lot easier for him to advise you, whether it's from a will making perspective, or in terms of inheritance tax planning. I've known Ellie for several years now. He's my go-to expert when it comes to wills and inheritance tax issues. He did my will, and he's also drafted wills on behalf of several of my clients as well. Unfortunately, I haven't got a glossy presentation, unlike Ellie. But what I do have is I've got a list of 12 questions that I'm gonna run through. If you have a pencil and paper, you might want to keep score, but don't worry about that if you haven't. Really, the idea is to just give you a flavor this evening of the sort of things that I'm able to do, and to help you decide whether you think that I may be able to assist you with your personal affairs. First question that I would ask is, do you use Microsoft Excel? That may seem like an obvious question, but you'd be amazed at the number of people that aren't familiar with Excel and don't actually use it. If you don't use Excel and you couldn't think of anything worse, then it makes my job almost impossible. Personally, I think that Excel is one of the most or greatest developments over the last 20 years, and has made life so much easier for everybody. So that's the first question. Question two is, do you know how wealthy you are? Again, a lot of these questions may seem very obvious, but I think when you actually sort of think to yourself whether you have the correct answer, you suddenly find that, well, there are things that you may not have taken into consideration, such as art or jewelry and things like that. But basically, when I talk about wealth, what I mean is your net asset value. And this is calculated by deducting your total liabilities, i.e. debt, mortgages, credit cards, and you deduct that from your total assets, your house, shares, pensions, etc. The next question, do you know how much you earn after tax and national insurance, both from employment and after taking into account unearned income? This was a question that was asked of Andrew Bailey, the governor of the Bank of England, last month, and his response was that he didn't actually carry that around in his head, and he thought that it was somewhere above £500,000. The actual answer was £575,000, but I mean, what's £75,000 between friends? Question four, do you keep up-to-date and comprehensive records which will enable you at the end of each tax year to complete your self-assessment tax return quickly and easily without recourse to an accountant? when it comes to completing a tax return, probably the most difficult aspect to it is actually collecting and gathering and collating the information that you require. Once you've done that, the actual filling in the tax return is the easy bit, and this is something that that I've looked at in quite a lot of detail over a number of years, and seen how much accountants charge for filling in half a dozen boxes on a form. I have an aunt who every year was charged £1,000 for completing her tax return. When I sat down to do it one year, it took me less than 10 minutes. Well, it was a case of just filling in the same boxes every time, and certainly her situation wasn't complicated, and she was paying a specialist unnecessarily. And this is, I often find this, I mean, with accountants and lawyers, you have to be very careful about the fees that you're paying. The next question, question 5, do you have pensions and or investments? And if so, do you know how the portfolios are invested, how they've performed over the past 5 or 10 years, and how much you're paying your independent financial advisor, fund manager, or pension provider? Just to give you a little example about in relation to this, a client and his wife came to me at the end of 2018 with SIPs and ISAs with a combined value of around about £2 million. They had been using or used a couple of fund managers over the preceding few years, and were very unhappy, with the performance of the portfolios, and also the fees that they were paying. The fees amounted to an average of 1.89%, and obviously on a couple of £1 million, you're looking at around about £40,000 in fees. When people are looking at the fees in relation to investment portfolios, there's a huge level of well, a huge lack of transparency, and often people are oblivious to how much they're being charged, and this is particularly pertinent when it comes to pensions. Recently, I saw a pension that one of my clients has, and 3 of the funds in the pension had annual fees of 4.5%, and it wasn't surprising that the returns have been pretty diabolical over the last 15 or 20 years, but not surprisingly, a lot of people don't look at the correspondence. They may be signed in or signed up with into a pension through their work, and they're simply oblivious to the charges, but also to the way that their investments are managed, and the levels of risk and the performance as well. Going back to the client with a couple of £1 million, I basically set out, I mean, he was so exasperated with his fund managers that he was well, actually considering just liquidating the portfolios and holding them in cash, which probably would have been the worst decision that he could have made. what I was able to do was to set out his options, and he's now moved to a platform where the charges amount to 0.25% per annum, and that includes any fees that he's paying to me as well. Just to try and give you a flavor, and this evening, this is probably the most important point that I want to make. So, but there are going to be quite a few numbers that are involved. If you have £2 million and assume a return of 5% on your investments per annum over the course of a 20-year period, at the end of 20 years, if you assume that no fees are paid, the value of your portfolio will be worth £5.3 million. My client, as I mentioned earlier, was originally paying 1.89%. If he continued to or retained his advisors, that £2 million would have been worth £3.6 million at the end of 20 years. Of that, the total fees that he would have paid would have been £1.1 million, and the drag, there would be a drag on the performance because of once you deduct the fees, that would have knocked off another £600,000. His situation now, that he's only paying 1/4%, is that at the end of 20 years, those portfolios, assuming a 5% annualized return, the portfolios would be worth a little over £5 million. So this effectively the saving, he's looking at almost £1.5 million potentially, depending on how long he keeps the pensions going. But the point that I'm making is here that that fees, or fund management fees, IFAs, they rack up and are compounded at a very high rate, and it makes a massive difference on what you're going to end up with. Question 6, do you know how much you spend each year, and whether it's more or less than your income? Whenever people talk, or when I'm sort of talking about budgeting, there's a very quaint quote from Charles Dickens that has stood the test of time. And it's basically annual income £20, annual expenditure £19, 19 shillings and 6 pence. Result, happiness. Annual income £20, annual expenditure £20, 0 and 6. Result, misery. And I think that I mean, in this day and age, a lot of people would benefit if they followed that general principle, not necessarily to the letter, but I think that there is a lot to be said for ensuring that that money doesn't rule you. You want to rule the money. And when I was looking at this previously, I saw a modern day version of this, which suggested that people in control of their finances tend to live longer and happier lives. Well, I think that there, again, there's probably some credence in that. Question 7, do you know when your home and car insurance policies are due for renewal, what level of cover you have, and whether your premium is competitive? There are a lot of people who are on automatic renewal contracts, never look at the premiums and the increases that inevitably are pushed through. Often don't fully, I haven't read the terms and conditions, and it only becomes an issue when you make a claim, and remarkably often people overestimate or underestimate their needs. The next question, question 8. Do you know whether your tariffs for gas, electricity, telephones, broadband, and TV are competitive? I suspect that gas and electricity is very topical at the moment, and people are obviously going to be concerned about that. The difficulty there is that unlike the situation a couple of years ago, or even a year ago, if you shopped around, you could almost guarantee that that you could find a cheaper deal. These days, there's no such thing as a good deal. Basically, everybody is likely to be paying exactly the same amount, i.e., around the price cap. Or when I talk about the same amount, I mean on a unit price basis. So unfortunately, there aren't the sort of savings that I would have been able to identify in the past, and certainly when I set up the Money Motco 9 years ago, just by switching gas and electricity for my clients, I was halfway or even all the way to saving the fees that I was charging. The same applies to broadband, mobile telephones, and just to give you a flavor for the costs, when I talk about a competitive price for a mobile phone, I'm currently paying a little over £12 a month for my mobile, and that is more than my needs are not. I don't use my phone sparingly, but it's these days you shouldn't be paying more than £15 to £20 unless you're using an awful lot of data or spending a lot of time abroad. The same goes for broadband and TV and telephones. Just to give you a bit of a flavor, I'm paying £53 a month for that, which equates to £636 a year for broadband, TV, and telephone. Obviously, if your TV requirements are much greater, I mean, Sky, you could be looking at it costs well in excess of £1,000 a year. The next question, question 9, do all your cash deposits pay interest? Over the last few years, looking for a decent rate of interest has been like looking for a needle in a haystack. However, I think that people have accepted that you can't get very good rates, and as a result have become a little bit too complacent, perhaps. Because today you can, I've got an instant access account paying 0.84%, and at the moment you can get a 1-year fix paying 1.6% is probably about the most competitive rate that I've seen. As interest rates go up, I think that there are going to be opportunities to get slightly higher rates, but I say that on a day when inflation has reached a 30-year high, and clearly the rates that you're getting on cash are, or the real returns are being eroded by inflation. In the same way that it's 30 years since inflation, I think, went above 6%, it's almost 2 years to the day since the US S&P index hit its lows, its COVID lows, and since then, it's worth mentioning, perhaps, I mean, just because it's the anniversary, that the US market has more than doubled over that time. So I think that puts into perspective the sort of returns that you can get in the stock market versus cash, but as anybody would tell you, the risks are far greater in the stock market. The next question, question 10, are your affairs fully automated, and do you know what all your passwords are? I think we are living in an age where you can't, you have to do everything online. You are going to require passwords for accessing any information. Firstly, I would just say that it's important to have a password that that is unlikely to be hacked, and I think that also having a degree of consistency is quite helpful, i.e. having one secure password for a lot of the your services and providers. The advantage of automating everything is that it's going to ultimately save you a huge amount of time, and the amount of time that when I'm dealing with clients and we're looking at whether it's a mobile phone bill or even gas and electricity, finding the right passwords can be a little bit exasperating, and I think that if you're doing this on your own, then it would certainly pay to ensure that you have an accessible record of your passwords, and but obviously they need to be kept secure. The next question is in relation to cars. When you last bought a car, was it second-hand and paid for in cash? The reason why I mentioned cars is that I have a colleague who provides a car finding service, and pre-COVID, the average car that he was able to source was less than 15 months old, had 8,000 miles on the clock, and he was buying them at almost a 40% discount to what they would have been new. The situation in the car market has been turned upside down, and certainly second-hand cars are commanding a much higher premium now than they used to. So the value that we're able to provide for that is certainly not as great at the moment, but it's something, a service that that people may want to bear in mind if they are using the Money Mopco services. The final question is a very open-ended one, but it's effectively, do you know whether you will have enough to live off when you retire? And I think that's a very, very difficult question for anybody to answer. Who knows what what the future holds, but it certainly pays to have some sort of budget and to look at what you potentially have to live off in terms of pensions in the future. One thing I omitted to mention in relation to pensions also is that a lot of people don't know what they will eventually be entitled to when it comes to state pensions. It's very easy to get the DWP, the Department for Work and Pensions, to provide a statement, and so you can be able to factor that into any sort of budgeting that you're planning on doing. The final, just to sort of recap on that, and I don't know whether you've been sort of keeping a score, but I think if you have scored less than 30 or 40%, then certainly I think that I might be able to assist you in some way, shape, or form. If you've got between 60 and 90%, then there's probably room for improvement, but hopefully I've identified a few areas that that you can it may be helpful to focus on. And if you've got all the questions 12 out of 12, then you really don't need to be listening to me this evening. The final thing that I would say before sort of handing or asking or seeing whether there are any questions is that on my website, which is www.themoneymotco.co.uk, there's you'll be able to see details of all the services that are on offer, and without necessarily, you probably won't be able to see it until afterwards. But if you look at the on the website, if you go on to what we do, and then right at the bottom, you can click on an icon, or it says click here, and it comes up with details of all the services that are available, and it's a whole raft of things. I don't do everything. As I mentioned at the beginning, if somebody requires a will, that will have to be done by a specialist such as Ellie, and by the same token, for more complex situations regarding insurance, I have brokers that will do health insurance, home insurance. I have somebody who will, a computer specialist. I've got a probably one of the best furniture restorers in the country. These are all contacts that I've developed over the last 9 years, and I can introduce them to you. So the Money Motco, apart from providing you with lots of scope to save money, and not only money but your time, but also to streamline your household budget. I can also provide you with other people that can help. Somebody who organizes travel, does travel arrangements, and people would associate that with a sort of a concierge type company, and to some extent I'm moving in, or have been sort of evolved, or the Money Motco has been evolving into that type of a business. Basically, it's a one-stop shop where I can advise clients on almost any issue that that they're affected by, and the cost of this, and I think that unlike a lot of businesses, people don't know how much they're going to be charged, and that's always a concern, particularly if you're using companies that charge by the hour. I have a flat fee of £1,000, and for that I will guarantee up to 2 days of my time, or a minimum saving of £1,000. So in effect, even if it costs you £1,000, the savings that you'll make are going to offset that. So to all intents and purposes, it's a free service. I'm happy to answer any questions, but I don't think there are any. So by all means, anybody can contact me after the meeting, and if you think that I can specifically help you with your activities. I tend not to do sort of ad hoc exercises in terms of if somebody would say, well, what's the best telephone provider or something like that. It really is a case of clients wanting to buy into the whole holistic service that I try and provide. But certainly I think that, well, I know that it offers incredible value for money, and I only wish that I'd kept tabs on how much I've saved my clients over the last 9 years, but it certainly runs into the millions, not the not the hundreds of thousands. Anyway, I've spoken for long enough, and happy to talk to anybody online or offline. I'll probably pass back to Ellie then.
Thank you, Andrew. Right, I can obviously tell you that I maybe could have answered one or two of his questions. Certainly didn't know the answers to a lot of them, but that was very informative. So what I'm going to do now is crack on with lasting powers of attorney. So we've talked about wills after you die. Then you've had a chat with Andrew, and you're on top of your finances. You're making sure everything is running. But what happens to running your finances should you actually lose capacity for some reason? So let's now talk about the lasting powers of attorney. There you go. Right, so the first thing is there are actually two separate types or different types of lasting power of attorney. There's the health and welfare, and there's the property and financial. Now, the old enduring powers of attorney were valid up until 2007 and dealt with financial matters, and they are still valid, but they were replaced in 2007 by these two, the lasting power of attorney for health and welfare and for property and finance. So let's have a look at them. We'll start with the health and welfare. So one of the most important things to understand is that if for some reason you were to lose capacity, nobody has the legal right to make decisions on your behalf. Not your spouse, not your family. In this context, next of kin does not exist. So your care package is going to be decided by the medical profession and the local authorities, and they will make decisions regarding your health and welfare. And I have seen and been involved in many cases where the local authorities do not even consult and actively withhold information from the families. So it's very important that you understand that without these things in place, you're leaving your life in the hands of strangers. So no one can make a decision on your behalf in relation to your medical treatment, the care that you have, where you should be treated, your dress, your diet, your routine, right through to a do not resuscitate or life-sustaining treatment. Okay, so whilst your family may know your wishes and they may know what you want or don't want, without giving them properly documented permission, they will not have a say. Now, attorneys actually, they can't compel a doctor to do something that the doctors feel that they wouldn't, that would not be a benefit for you. So if we have a look at an example, I had a client of mine who had dementia, but he also had prostate cancer. Now, as part of his dementia treatment, he would have to go for an injection once a week. And because of his dementia, he didn't really understand what was going on. And that distressed him. He was very agitated and distressed for 2 or 3 or 4 days after the injection. So in the end, his daughter said to the doctors, look, you know, I hate to see my dad suffer, and I can't take it anymore. I want you to withdraw the cancer treatment, because, you know, if the cancer doesn't get him, the dementia will. And, you know, if we withdraw the treatment, I know that my dad may have a shorter lifespan, but at least he'll have a better quality life while he's still with us. And the doctor said no. They said, you know, that's not our job. We want to do the best that we can for him and keep him alive. So at this point, daughter said, well, actually, I've got power of attorney for dad, and I want the treatment to stop. And so they did that. They had to comply. But what the power of attorney does not allow her to do is to say to them, well, you know what, I want you to try this new treatment or this experimental drug or something. So she can't compel the doctors to do something that they don't want to do, but you can withdraw the treatment and you have much more control over that person. Oops, my mouse has disappeared. Okay. I need a techie guy. Here we go. Okay, so that's the health and welfare. So the health and welfare deals with with the medical profession and the doctors. The finance and property deals with your property and financial matters. And again, that deals with all your financial. So it allows your attorneys to deal with all your finances, pay your mortgage, pay your bills, collect money that you're owed, dealing with investing money. So if Andrew's looking after you and you're incapacitated, then your attorneys can actually still liaise with Andrew and make sure that everything is still running. I actually had a client of mine, Mary, who actually had a stroke. She suffered a stroke, which put her in a coma for 4.5 months. And during that time, her family asked to cancel her mobile phone contract. The company said no. They asked the banks to cancel the redundant direct debits. You know, she didn't need Netflix or Prime or anything like that anymore, but the bank said no. And she actually did have private health insurance, but the insurance company wouldn't allow them to make a claim. And this is all because they didn't have a lasting power of attorney. All the institutions, the banks, the insurance companies, they all said the same thing. You know, look, you know, we cannot give somebody access to our customers' accounts without properly documented permission, right? Because we don't know whether Mary would have actually agreed to this or not. So without power of attorney, our hands are tied. If Mary had given you power of attorney, then we would gladly oblige and cancel the direct debits and deal with this insurance claim and cancel the mobile phone contract and so on. So something very important to understand also is how the banks deal with someone who loses capacity. Okay, if you have a joint account and one of you were to lose capacity, the bank's policy is to actually freeze that account, right? Because they now have a vulnerable person and they don't know whether that vulnerable person would actually be consenting to the other one taking all the money out. And so rather than risk, you know, being sued or, you know, having someone go after them, their policy is to freeze the accounts until someone actually goes to court and gets an order or comes forward with a lasting power of attorney. And this actually also includes business accounts. So for those of you who are actually in business, if you have partners, business partners, co-directors, and so on, and somebody were to lose capacity, the banks will also freeze the business account. So you can imagine that means you can't pay your suppliers, you can't pay your wages. The old days of removing a director or a partner under the Care Act are gone. So again, power of attorney are really crucial, to keep the business going. So what is the solution? What is a power of attorney? Well, a lasting power of attorney is a document where you appoint someone to act on your behalf if you are no longer able to make decisions for yourself, right? And, decisions or being incapacitated, it can be temporary or it could be permanent. So most people think on a permanent basis, something like dementia, but you can actually be incapacitated temporarily. As in Mary's case, she had a stroke, she was in a coma, but she eventually made a recovery. So whilst you're not able to make those decisions or not able to manage your own affairs, you choose exactly who you would want and who knows what you want to look after you in the event that you can't do so yourself. Okay, in order to make a power of attorney, obviously you have to have capacity yourself to appoint your attorneys. But there are certain things that attorneys cannot do under an LPA. They cannot make large gifts. They can't start giving your money away, okay? They cannot manage discretionary funds. Now, this is actually, a lot of people think that doesn't apply to me, but it's actually probably one of the most important reasons for me that you actually have one. So I had two clients, brother and a sister. Their dad had dementia. And so they decided that the best course of action, because he couldn't really look after himself anymore, was to sell his house and to have him move into a cottage next door to the daughter, so she was next to him, so she could look after him every day. And that's what they did. And what happened was, is that they actually wanted to invest the money, because they realized shortly that the money that they got from his house was such that he was likely to outlive it, because physically he was okay. It was just, he didn't have mental capacity. And so once the money ran out, the burden would fall on them to actually pick up the tab. And that would be a financial, even if they split it half and half, it would still be a big financial strain on both of them. And so they wanted to invest the money, but they weren't allowed to, unless there's specific word in the lasting power of attorney. So, if Andrew is managing a portfolio for you, for example, and you lose capacity, your attorneys can't instruct Andrew unless there's specific wording put in there specifically for that purpose. Attorneys cannot pay themselves a fee unless they are a professional attorney. They can't purchase assets from the donor at below market rate. So if you're power of attorney for your dad, you can't sell his house to you, or buy his house off him at half the market value. They can't do tax planning, and they can't use their position to benefit themselves. An attorney is managing someone else's money and making decisions for somebody else for their benefit, not for their own, or for your own benefit. If you do not have lasting powers of attorney, then the only option you have is to go to court, and you have to apply for a deputyship order from the Court of Protection. And I can tell you, it is a nightmare. It is a nightmare financially, and it is a nightmare emotionally. So what's actually involved? Well, if you have to go to court, typically it's going to cost you nearly £4,500 to bring that application to court. There's application fees and hearing fees, the security bonds, and that's not including what you'd probably end up paying to a solicitor to actually prepare and bring that application to court. So, if you add those sort of costs on, that it could run into 8, 9, 10,000 quite easily. And then there are ongoing costs. The courts will supervise you. It's actually quite onerous. They will actually make sure that you're still fit and healthy, still fit and managing the person's finances on their behalf. They're constantly looking over your shoulders. You have to account for every single penny that you're spending on behalf of that person. They could place limits on how big a check you could write. So let's say they say you can't write a check for more than £500, right? And then, I don't know, school fees come up and you need to pay the school £1,000. You have to go back to the court, get permission to write that check for £1,000. They will say to you, yes, no problem at all, you can do that. You write the check for the £1,000 to the school, and then you get a bill for £250 from the court for giving you that permission. They can turn up unannounced, they give you visits. As I say, it is a nightmare. So let's have a look at the consequences of what happens if you don't have them. So some of you may recognize this name, others may not, but Betty Figg was in the news a few years ago. Betty was an 83-year-old dementia patient. She was actually in a private facility, but it was being funded by the local authority. And she had two daughters. The older daughter was called Rosalind, and for the life of me, at the moment, I can't remember the younger daughter's name. But basically, Rosalind was very unhappy with the level of care that her mother was getting. All right, she would go to visit her at the care home, and she'd have a plastic cup in her hand, and it would be shaking like this. She was very withdrawn. You know, she would just stare into space. And so Rosalind decided that enough was enough. She sold her business. She adapted part of the downstairs of her house. She put in a new bedroom with an ensuite, you know, wet room and some garden rails and safety features. And she went and she brought she brought her mother home. Within 48 hours, there was a knock at the door. Rosalind opens it, and in front of her, she's greeted by two social workers with 6 big, burly police officers behind them, with a battering ram ready to stove in the door. Had she not answered the door, they would have smashed their way in. And they literally barged past her and physically removed Betty from her house. And because, you know, all the commotion was heard by all the neighbours who'd come out with their mobile phones, you know, to add indignity to the poor old woman, they shoved this tea towel over her head, and they sort of bundled her off into this car. And in fact, in an attempt to get away from all the photographers and the shouting from the neighbours and the friends, they actually clipped a lamppost or a bollard on their way out, which, you know, that could have been much worse, further endangering the old lady's life. Now, all of that drama, all of that expense of having to go to court, which Rosalind actually did. She actually took the local authority to court, and 7 months later, she was actually allowed to bring her mother home. But all that anguish and stress, and not to mention the cost of going to court, could have been avoided had Betty given her daughters power of appointment, power of attorney. So it's getting a bit late in the day, isn't it? These are a couple of other cases that appeared in the news, both similar in that they suffered brain damage as a result of motorised scooter. Well, Paul Briggs on the left was a police officer who suffered a motorbike accident, and Barry Bissell on the right-hand side, Bradley Bissell on the right-hand side, actually was on a motorised scooter, but both suffered brain damage. On the left side, in Paul's case, the doctor said there's nothing more we can do, and his wife, his mother, they all went to the doctors and they said, look, this is not what Paul would have wanted, you know, please turn the life support off. In fact, the turning thing that turned them most was their young daughter, who said, that's not daddy. You know, she didn't recognize her dad anymore. And the hospital refused. They said no. And I think the reason that the hospital refused was that once every 3 or 4 weeks, one of the various machines that Paul was hooked up to went ping, and so they, you know, refused to turn anything off. In Bradley's case, Bradley's wife did have power of attorney, and she said, you know, I've got attorney for this. Is not what Bradley would have wanted. I've got power of attorney. Please turn the machines off. And so the hospital complied. And I don't know, depending on whether you're looking on a mobile or a screen there, but if you can see the little section at the bottom that's in red, it quotes Bradley's wife as saying that she genuinely believed that if she didn't have that piece of paper, she wouldn't have been able to get out of bed in the morning. So that's how important they are. Okay, it can be heartbreaking for families to be excluded from such important decisions, right? And if you don't make an LPA, then court is your only option. So what is an LPA? Well, lasting power of attorney, it's a 20-page document that outlines the donors, who the attorneys are, replacement attorneys, if your main attorneys can't act, how they will act. You've got someone called a certificate provider. These are people that sign a document to say that there's no undue influence or coercion going on. You can put your guidance, restrictions, you have to sign it, and then it's submitted to the court along with a registration fee, and it's done. Now, court of protection figures are showing that currently it's taking over a year to get a deputyship order. In fact, this slide is a little bit out of date because since the pandemic, it's actually taken around 16 weeks now to actually get a lasting power of attorney registered, but it's still a lot quicker and it's still a lot cheaper. And I kind of liken lasting powers of attorney to insurance policies. Okay, the best scenario is that you pay your money, you file them away in a drawer, and they never see the light of day. You know, they never get used. But if you were to lose capacity for whatever reason, they are the most important tools that your loved ones, your family have to make sure that you are looked after in the way that you would have wanted. So whether it's you concerned about someone looking after you, should you lose capacity, or perhaps you've got a relative, a parent or a loved one that you want to make sure that they're looked after in the way that they wanted, and be involved in those decisions rather than having it made in the hands of strangers, then the power of attorney is really your only option or your best option. Okay, so I am concluded. So let's just have a look if we've got any questions. The first one is it's not a question. We've had someone apologizing because they had to leave. Someone has put, I still have an enduring power of attorney. Do I still need an LPA? As I sort of at the beginning, the enduring power of attorney were replaced by the LPAs in 2007, but it is still legal. But the enduring power of attorney is still predominantly a financial document. So you can have either an enduring power of attorney and take out the health and welfare, or you could have replaced the enduring power of attorney with both the property and finance and the LPA. Someone has put, who can be an attorney? Well, anyone over the age of 18 can be your attorney. So again, typically it would be your spouse, your partner, adult children, or so on. And someone says, what happens if I or my attorney dies? Well, if you die, then your power of attorney dies with you, because it's only a document that deals with your affairs while you're alive. After you die, then we are then looking at your will taking over. And if one of your attorney dies, if you have more than one attorney, then the other attorneys will still be able to act. If you have a substitute or a reserve attorney, they can then step up because your main attorney dies. But if you only had the one attorney with no reserves and no substitutes, and that attorney dies, then your LPA is now invalid, and you'd have to take a new one out. And let's hope that you have capacity to do that. How can an LPA ensure pension investment decisions can be made by attorneys? So this is one of the advantages of dealing with someone like me rather than a professional. I put specific wording into the LPA that allows your attorneys to talk to third parties. So they can delegate to third parties such as your investment or your pension advisors, so they can manage those funds for you. Okay, so
perhaps I could just say one thing in relation to the wills and powers of attorney. From where I sit, I mean, it's all well and good having these documents, which are, I mean, as Ellie's explained, are absolutely vital. But it's all well and good having them. But if your attorneys and in the event of you dying, your executors don't know what you actually have, in terms of assets and all the passwords to all of your services, then it creates a huge amount of work, either when you're alive and your attorneys are having to deal with your affairs, or when you're dead and you're not around to help them. So this is where I think I add a huge amount of value in terms of, with my spreadsheets, in terms of hopefully they would contain all the information that either the attorneys or the executors would need.
Okay, got a couple of other questions. If attorneys don't agree between them, how is this dealt with? So it's dealt with in a couple of ways. First of all, when the power of attorney is set up, attorneys can act either jointly and severally, which means they can act independently, or they have to agree. Now, normally I would recommend jointly and severally. If they disagree, you have got a problem because the decisions can't be made. If attorneys are acting jointly and severally, it means they don't have to actually confer, because imagine you've got two attorneys and one of them is on holiday or unavailable. The other one can still can act without having to refer to them. So generally speaking, he who has the document actually has the power. What are the total costs for an LPA approximately? So typically to draft an LPA is £175 for each one. How many do you need? Well, for a single person, you would need two, because you would need a financial and the health and welfare. If it's for a couple, that ends up being four, because you have two each. You both have a financial and you both have a health and welfare. And in those cases, I will normally, as a package, do some sort of discount. So if the £175 each, normally I would knock 25 or £25 or something off each one. So bringing it down to maybe £500 for a set of four. There is also an additional cost for registering the LPAs. This has nothing to do with Barnet Wills, or in fact with anybody that drafts them for you. Before they can be legal, they have to be registered with the Office of the Public Guardian, and they will charge £82 to register a power of attorney. But if for certain people, if they are on certain benefits or low incomes, there is a remission of between 50% to 100%. So they can be either half price or free in certain circumstances. But if you don't qualify for those, then it's an £82 to actually register them. Okay, so there are no more questions, but thank you everyone for coming along this evening. And for those of you that stayed the course, we've still got 5 minutes left, but so we did it within time, thankfully. You'll probably get a call from the lovely Joanne at some point, who does my quality assurance. We'd really love your feedback, so that when we next hold a webinar, we will know what we did that you liked and what we did that you didn't like, so to make sure that we can make the experience better. So thank you very much, and good night. And if you have any questions, by all means, please do email. We will respond to all emails. Good
Thanks,
night.
Ali. Thank you very much for hosting that, and thank you everybody for listening to us.